Ms. Hubner apologized for the amount of time that it has taken for the Commission to put out its proposal, and I think you should not, mostly because it's not your responsibility personally, but also because the gain in understanding that has occurred through the interactions that we have had across the industry and with policymakers over the last couple of years has really achieved a lot. And we will, as a result, end up with much better considered legislation and then ultimately rulemaking to follow. There are a few points that I would like to make because I do think there's more work to be done in terms of increasing understanding and critical issues. In particular, over the past couple of years, we've seen an acceptance that one size does not fit all for CCP recovery and resolution, and that there's a great importance to place on flexibility, both for the CCP, provided that its rules are clear and its options for flexibility are described in its rules, and perhaps more importantly, flexibility for regulators and resolution authorities should they be required. There are three critical differences that I want to cover a little bit about DTCC, and these are some of the things that really need to still be considered as we work through the final processes of legislation and recovery and resolution, which will then, of course, have an impact not directly on DTCC, but on the equivalence determination and thus the opportunities for further participation on a cross-border basis between U.S. institutions in the EU and European institutions in our markets in the U.S. Just a brief introduction for those of you who aren't familiar. As mentioned earlier, DTCC is a user-owned and operated CCP. We are technically a private company. We're owned by our shareholders. We have 3 clearing agencies, 2 CCPs, and the Central Securities Depository for the United States. Our 2 CCPs clear the U.S. securities market, common equities, common stocks, and the U.S. fixed income market, the U.S. Treasury buy-sell market, and repo clearing, as well as mortgage-backed securities. Those are in 2 separate legal entities, and then, as I mentioned, we also have the CSD. We have a holding company structure that sits above that, and we have about 350 shareholders. Their ownership of equity in the institution is determined by their participation in each of our clearing agencies. So the larger participants are larger shareholders, the smaller participants are smaller shareholders. But we work to have representation from all categories of participants on our board of directors and our risk committee and various advisory committees throughout the process. That organizational structure is different, and those differences, I think, are relevant and important to understand in the recovery and resolution context. Earlier I mentioned that there's a difference in terms of capital. If we are required to have more capital, that capital comes from our shareholders. Now, it comes from our shareholders in advance, so it doesn't have the pro-cyclical issues associated with trying to raise capital in a crisis circumstance, but it's still relevant to note. We don't have public shareholders. Second, in terms of the structure, there's been a lot of focus on different types of structures where perhaps you have a for-profit, publicly traded holding company that sits atop a CCP that's regulated. It's important, again, to understand we have 3 different legal entities and a holding company structure that sits atop that. Where that comes into play, and this is why I say the details matter, that in particular circumstances, if the desire of the policymakers is to ensure that the holding company is on the hook for certain types of losses, that could actually create issues for us. For example, if we were to have a loss associated specifically with operations in our fixed income clearing, say a failure of a payment system, you would not want that to infect the opportunities for the Central Securities Depository, the capital that backs the Central Securities Depository, or the Securities Clearing Organization if it's an unrelated matter. So it's just something, again, to keep in mind. Similarly, non-default losses, which I'd like to note, again, the details matter. They're not all the same. There are a variety of types of losses covered under that category. Again, if the desire is to say non-default losses need to be covered in another way, you do need to look at what the incentives are and what the reasons are for seeking that treatment, because it may not apply across the board. For DTCC, again, because our participants are our shareholders, our non-default losses are generally covered with our clearing fund. Not that we have thankfully ever had to dip into it for that purpose, but that provides an appropriate structure for us, giving our ownership and holding company structure. And if you were to treat that differently as a requirement of regulation, you would actually create unintended problems. A second significant difference that I'd like to point out, and it's been discussed before, and we're glad to see that it's greater understanding has been achieved over time on this, are the differences between cash securities clearing and derivatives clearing. Much of the focus has really been on derivatives clearing, and we certainly understand why in view of some of the drivers or the perceived drivers of the financial crisis, but it's important again to understand the differences. For example, there's been a significant amount of debate about recovery tools and which recovery tools ought to be available, whether certain recovery tools ought to be favored over others, or whether certain recovery tools should even be prohibited. In that context, it's useful to understand that certain recovery tools, variation gains, haircutting, initial margin haircutting, forced allocations, and tear-ups, really don't work for cash securities clearing. They're simply different structures. So again, when particular requirements are put in place, it's important to examine the different structures that exist in the industry and what the impact would be. Now, those things are academically interesting, and I'd be delighted to comment on them, but they don't really apply to DTCC. My primary concern is to ensure that we don't suffer unintended consequences there. And then a third significant difference that's important to bear in mind, particularly right now, are differences between the U.S. legal and regulatory regime and the European legal and regulatory regime. And even to take that one step further, there are differences between the SEC, Securities and Exchange, regulated clearing agencies such as DTCCs, and the CFTC regulated clearing agencies such as CME groups and the Intercontinental Exchange. One reason these things are important is, again, if there are particular requirements that might be included within an equivalence regime, and if you look at that too strictly, you could, again, cause some unintended consequences that would be very difficult to alleviate as a part of the political process or the regulatory process. Let me give you one example: segregation and portability. It's been a substantial focus. There was a resolution of concerns about equal treatment for segregation and portability on the CFTC side, where we do have an equivalence determination. But I'd just like to remind everybody that for the SEC-regulated clearing agencies, we do not yet have an equivalence determination. We are still in a grandfathered period. Segregation and portability, customer asset segregation by law, operates very differently on the securities side in the United States, which is really to say for our CCPs, we do not have segregated customer positions or segregated assets. And that's a structure that exists in U.S. legislation. It would not easily be changed. That's not to say that there aren't good structures for customer protection and for portability of customer positions from one broker-dealer to another. But again, if you're looking for equal treatment in the legal structures, that may be something that's difficult to achieve. So again, those differences become potentially important. So just a few concluding themes that I'd like to note. Again, one size does not fit all. I think flexibility is very important for the CCP, again, within the construct of transparency. The CCP's rules should be clear. The participants should understand what risks they may be subject to, what they may not be subject to, and what tools the CCP has at its disposal. To the extent that the CCP has the opportunity to employ judgment or flexibility in a crisis scenario, it should at least be clear how that may happen and what parameters, on what parameters the CCP may act. Flexibility for the resolution authority, I think, is obviously critical, and the only thing that I would second there from the previous panel as well is that you do not necessarily want to be too prescriptive about exactly how outcomes would come into play in the resolution context, because you want to think about what the incentives may be. So again, you definitely want your participants to understand in a crisis scenario that the resolution outcome is at best uncertain, because you don't want that to impact participants' behavior where applicable in the recovery context. Transparency, again, is important, as I've covered. And then the last thing I'd like to say to the policymakers in the room is trust your experts. A lot has been learned over the course of the last couple of years. You have a lot of participants, both practitioners and academics, who are become familiar with the industry, who understand these differences, and who can be careful about the language that is used and what it may mean in different contexts, because those details will matter.